Good morning, this is your Kelso Report for Tuesday, January 29th. I'm your host, Clark Kelso. The Ninth Circuit has given us a case involving attorney fees to a prevailing defendant in a copyright action, a habeas corpus decision involving application of federal law back in the 1990s, an in-bank grant in a case involving the commercial activities exception of the Foreign Sovereign Immunities Act, and an application of the discretionary function exception to the Federal Tort Claims Act in a suit against the Securities and Exchange Commission. Finally, we also have a decision from the Second District involving the primary assumption of risk defense in a healthcare context. Well, let's start with the Ninth Circuit and attorney's fees in copyright. The long-running copyright and trade secret litigation between toy giants Mattel and MGA Entertainment over the Bratz doll appears to have run its course. But it took 2 full-length trials and 2 sets of appeals to finish the job. On the second retrial, the jury rejected Mattel's claim that MGA had violated Mattel's copyrights by selling the Bratz doll, and the district court awarded attorney's fees to MGA, the prevailing party. The jury also found on a trade secret counterclaim that Mattel had misappropriated MGA's trade secrets. Mattel appealed both the attorney fee award and the trade secret judgment. Well, the Ninth Circuit pretty well ended things in Mattel versus MGA Entertainment by affirming the attorney's fees and dismissing the trade secret claim. According to the court, the trade secret claim did not qualify as a compulsory counterclaim, since it did not arise out of any of the same set of facts, and since it was not compulsory, the claim should never have been entertained by the lower court. As for attorney fees, Mattel tried to argue that they were improperly granted since Mattel's copyright claim was not objectively unreasonable. The Ninth Circuit rejected this argument, noting that argument suggested a return to the days when attorney's fees could be awarded only when a claim was frivolous or in bad faith. The law now, however, gives the court in a copyright action discretion to award fees to the prevailing party when such an award would further the purposes of the Copyright Act. According to the court, MGA's successful defense furthered the purposes of the Act because its defense secured the public's interest in a robust market for trendy fashion dolls populated by multiple toy companies. So a bad day for Mattel in court. Next, habeas corpus decision. The Supreme Court, of course, recently reaffirmed unanimously in Green v. Fisher that in making the determination in a habeas proceeding whether the state courts had rendered a decision contrary to clearly established federal law, that clearly established federal law must be assessed as of the time of the final state court adjudication on the merits. In Thompson v. Reynolds, the Ninth Circuit majority applied Green in holding that the Supreme Court's 1985 decision in Oregon v. Elstad was the proper standard for assessing the state court's decision, and that the Supreme Court's 2004 decision in Missouri v. Siebert was not relevant to the court's habeas review. Both Elstad and Siebert dealt with the admissibility of confessions that resulted from so-called two-step interrogations, where a suspect is first interrogated without the benefit of the Miranda warnings, and then, if a confession is elicited, the suspect is given the Miranda warning for the purposes of restating the confession. Under Elstad, it appeared that this process was acceptable so long as no coercion was used in the pre-Miranda interview. And relying on Elstad, the state courts had rejected the petitioner's claims in April of 2004. Only a few months later, however, the Supreme Court in Siebert held that where the two-step interrogation process was deliberately used, post-Miranda statements related to the same substance as pre-warning statements were inadmissible, unless the midstream Miranda warnings actually would apprise a reasonable person in the defendant's shoes of his full rights. Well, notwithstanding the close proximity of the state court's decision and the Supreme Court's new holding in Siebert, the Ninth Circuit held that the only issue before it was whether the state court's decision was a reasonable application of the earlier decision in Elstad. Finding that it was a reasonable application of Elstad, the Ninth Circuit rejected the habeas petition. Next, the Ninth Circuit has granted en banc in a Foreign Sovereign Immunities Act case. Last September, a panel of the Ninth Circuit held in Sachs versus Republic of Austria by a 2-to-1 vote that the commercial activity exception in the Foreign Sovereign Immunities Act did not apply, and therefore jurisdiction over the Republic of Austria did not exist, when the plaintiff purchased a Eurail pass in California from Rail Pass Experts, a Massachusetts company that actually is owned by some 30 European railway companies. The plaintiff was then injured while boarding a moving train in Innsbruck, Austria. One of the judges in the majority reasoned that the Austrian National Railway did not have sufficient day-to-day involvement in the Massachusetts marketing company, so that its sale of the Eurail pass to the plaintiff could be imputed to the Austrian Railway. The second judge in the majority reasoned that even if the sale of the ticket could be imputed, that commercial activity did not have a sufficient nexus to the tort and the plaintiff's injuries to trigger the exception to sovereign immunity. The Ninth Circuit has now decided to rehear this case en banc, so maybe at least we'll get a majority viewpoint instead of a really 1-1-1 split. Finally, for the Ninth Circuit, we have a case involving the Federal Tort Claims Act. Under the Federal Tort Claims Act, an injured person can sue the United States government for certain torts, including negligence, committed by federal employees acting within the scope of their employment. However, there is a big exception when the government activity falls within the so-called discretionary function exception. Under the discretionary function exception, government decisions or actions that substantially involve the weighing and balancing of economic, social, and policy considerations may not be the basis for a tort action, since we don't want the courts second-guessing the reasonableness of those sort of policy decisions by executive branch officials. In Dictor Mad Family Partners versus United States, the Ninth Circuit adopted the decision of the District Court, which easily dismissed a suit against the Securities and Exchange Commission, alleging negligence in the SEC's failure to discover Bernie Madoff's Ponzi scheme sooner than it did. Now, lots of investors obviously were injured by Madoff's scheme, and if the SEC had discovered it sooner, many of those investors would not have been injured. The complaint was, in fact, based on the content of the SEC's Inspector General's own report, which identified all sorts of red flags that might have triggered an earlier enforcement action. However, the commitment of investigative resources and the decision whether to commence an enforcement action is a quintessential example of a decision committed to the discretion of the executive branch. So the District Court properly dismissed the tort claim under the discretionary function exception. Finally, today we have a case involving primary assumption of risk. This is an important case involving an injury to a professional home caregiver. The Second District held in Gregory v. Scott that the caregiver's tort action was subject to the primary assumption of risk defense. The defendant had contracted with a home care agency to provide in-home care for his 85-year-old wife, who had suffered from Alzheimer's disease for at least 9 years. The company assigned the plaintiff to provide the services. In 2008, when plaintiff was washing dishes and had a knife in her hand, the plaintiff made contact with plaintiff and reached for the knife the plaintiff was holding. As a result, plaintiff was cut on the wrist with a knife, suffering significant injuries. Plaintiff testified that although her patient's eyes were open, she didn't even appear to be seeing the plaintiff. The Superior Court dismissed on the defendant's motion for summary judgment, reasoning that the risk of this type of injury was squarely within the scope of the caregiver's employment. Now, as I think we all know, the primary assumption of risk doctrine has most commonly been applied to sports or recreational activities. But the Second District noted that the California Supreme Court has indicated that the doctrine need not be so limited. And there have been other cases in the healthcare context where the doctrine has applied because the healthcare professional has been retained to confront and deal with precisely the type of risks, in this case risk of violent behavior, that injured the healthcare worker. Now there is a dissent in this case, and since the situation dealt with here is a common one faced by families around the state, it would not surprise me to see California Supreme Court granting review. And that's it for today's Kelso Report. Have a great day in the law.